Hello everybody, welcome to MOOC's Access to Justice program. I am Saika, Advocate High Court, and today I am going to teach a module on Permanent Lok Adalat prepared by Dr. Bharti Yadav, Assistant Professor, National Law University, Delhi. The objective of the program is to appreciate the idea, the need for Permanent Lok Adalat, to understand the public utility service, to verify the organizational setup of Permanent Lok Adalat. I'm going to do this presentation according to the following scheme. There will be an introduction, and I'm going to talk a little bit about public utility service, need for PLA, organizational structure of um, PLA, composition, summary and allowance, tenure, removal of members, place of sitting, jurisdiction, proceedings, award, and I'm going to conclude this program with a brief summary of today's presentation. Introduction. Why do we need a Permanent Lok Adalat? Now, there are few objectives for which the Permanent Lok Adalat Act was enacted, and these are to reduce the burden of the judiciary, for speedy disposal of cases. The Legal Service Authorities Act provides for Permanent Lok Adalat. The central authority on every state shall, by notification, establish Permanent Lok Adalat as such places for two purposes. Number one, for exercising such jurisdiction in respect of one or more public utility services, and for such areas as may be specified in the notification. Public utility services. Now, how do we define or understand public utility services? Public utility services means transport for the service of carriage of passengers or goods by air or water, or postal telegraph or telephone services, or for supply of power, light, water to public by an establishment or system of public sanitation or services in the hospital or dispensary. Insurance service, and may include any service which the central government or the state government, as the case may be, in the public interest by notification declare the public utility service for the purpose of this chapter. This is how the public utility service has been defined under the Legal Service Authorities Act of 1987. Now we come to the question of why do we need a Permanent Lok Adalat? The need for establishment of Permanent Lok Adalat was highlighted by the Delhi High Court in Abdul Hussain versus Delhi Vidyut Board. According to the available statistics, there is huge pendency of cases in various courts, and the number of pendency rates almost to 3 crore. In our country, there are only 10.5% judges, 10.5 judges per million population to dispose of these cases. In such cases, and particularly keeping in mind the objective of speedy disposal of cases and reducing the burden on judiciary and the sessions court, the Permanent Lok Adalat was provided for under the Legal Service Authorities Act of 1987. The Indian Parliament then enacted the Act, and the Act was not to enforce did not come into force for almost 8 years after its enactment. It was only on November 9th, 1995 that the provision for the Act under Chapter 3 was made. And the Chapter 3 provides following. It is in the interest of the citizen of the India that Permanent Lok Adalat are established and held continuously for facilitating speedy disposal of all kinds of cases. Permanent Lok Adalat must be set up in various departments of the government and subsidiary departments. Organizational setup of Permanent Lok Adalat. What is the composition? The flowchart here talks about the composition and establishment of Permanent Lok Adalat as provided under the Legal Service Authorities Act. Now, if you look at this flowchart, you can see that it provides for the first block talks about the salary and allowance of the members of the Permanent Lok Adalat, the tenure of the members of the Lok Adalat, the procedure for the removal of the members of the Lok Adalat, place of sitting and working hours, jurisdiction of the Permanent Lok Adalat, proceeding before the Permanent Lok Adalat, award of permanent lok adalat, that is whether the permanent lok adalat, the decision or the award made by them, is it binding or not, and what is the effect. Now coming to the composition of permanent lok adalat. Permanent lok adalat comprises of 3 members total, one person to function as the chairman of the permanent lok adalat, and 2 members. Now who are to be appointed as the member, and how are they to be appointed. Every permanent lok adalat, the act provides the following. Every permanent lok adalat established for an area shall consist of 2 persons who has been a district judge or an additional district judge, or has held the judicial official higher than in the rank that of the district judge, shall be the chairman of the permanent lok adalat. So the chairman has to be, as per the act, the chairman has to be either a district judge or an additional district judge, or any person who is higher the rank of the additional district judge can be alone be appointed as the chairman of the permanent lok adalat. Additionally, there are 2 members in addition to the chairperson, and the 2 members should have adequate experience in public utility service. Now, in the beginning of this lesson, of this module, I had explained what public utility service stands for. So any person who has adequate experience in public utility service and is nominated by the central government are to be appointed as the member of the permanent lok adalat. Salary and allowance. What should be the salary and allowance of these members? Now, for the chairperson, when a serving judicial officer is appointed as the chairperson, he shall receive the salary allowance and other prerequisites as are admissible to the serving judicial officer. So, for instance, if an acting judge, additional judge or additional district judge has been appointed as the chairperson of the permanent lok adalat, in that case, he shall draw the same salary which he is entitled to as the judge or as an additional district judge. Now, when the retired judicial officer is appointed as a chairperson, he shall be entitled to a monthly fee of last drawn salary less than the amount of the pension received by him. So, what happens in case where the chairperson of the permanent lok adalat is a retired judge? In that case, the law says that the chairperson in that case shall get the same salary, which would be equivalent to the amount which he was drawing just before his retirement, and that should be an amount which is less, but it should be an amount which is less than the money which he receives as his pension. Salary and allowance of other members. So what should be the allowance for the other 2 members of the permanent lok adalat? Any person shall be entitled to a sitting fee of rupees 500 per sitting. So if you have to understand over here that the other members are not a permanent member of lok adalat. They can be a member for any particular or individual sitting also. So in that case, the law provides that the fee should be rupees 500 per sitting. The chairman and other person shall be entitled to such travelling and daily allowances or official tour as are admissible to Group A officers of the central government. So officers which are gazetted officers under Group A of the central government are entitled to certain salary and travel allowance. So the law says that the member and the chairperson of permanent lok adalat are entitled to similar benefits and allowances. The rule for appointment and service condition for the chairperson and other person in permanent lok adalat have been made in 2003. So it was only in 2003 these rules were enacted as to the salary and the allowances. Before appointment, the chairperson and other person shall have to undertake that he does not and will not have such financial or other interest as is likely to affect his function as such chairperson and other person. So the person joining as the chairman or the person joining as the member of permanent lok adalat has to give an undertaking in written and signed by him, stating that it is not going to he shall not have any other financial interest as is likely to affect his function. So he should not be in any other position, official position or ranking where he has a financial interest, and as a matter of fact that would affect his position as a member of permanent lok adalat. the tenure of members. What is the tenure as provided under the law? The chairperson and other person shall hold office for a term of 5 years and shall not be eligible for reappointment. So it is a one-term appointment only as provided under the Act. Both the chairman and the other two members of the permanent Lok Adalat can only be appointed for one term, which is for a period of 5 years. Chairman and other person may by writing under his hand an address to the central authority, or as the case may be, the state authority, resign his office at any time or be removed from his office. So, is once appointed as a chairperson or member of the permanent Lok Adalat, the law says that the chairperson or any of the member can at any time be removed or may resign from his office if he provides in writing to the central authority under the Act that he wishes to be removed from the office. When the chairman is unable to discharge his function due to absence, illness, and other cause, the senior most in order of appointment person or permanent Lok Adalat holding the office may discharge the function of the chairman. So, where there are three members, one chairman and two other member of Lok Adalat, and the chairman, for the reasons specified under the law, such as illness or any other cause which is valid as under the law, is has remained absent from his duties for a long period of time, then in that case, the senior most member in chronological order of the permanent Lok Adalat may discharge the duties and function of the chairman of the permanent Lok Adalat. For the time being, shall discharge the function. The chairman or any other person ceasing to hold the office as such shall not hold an appointment in or be connected with the management or the administration of an organization which has been subject to the proceeding under the Act. So, when a person, when the members or of the Lok Adalat or the chairman is appointed, any person who is appointed to as either in the position of chairman or as the member of Lok Adalat, in that case, he should not simultaneously be holding office with any organization that has been subject to the proceeding under the Legal Service Authorities Act of 1987. Removal of the members. So, how can the member during his tenure of 5 years can be removed from the position of the chairman or as the member of permanent Lok Adalat? The central authority or the state authority, as the case may be, may at any point remove the officer, a chairman or other person who has been adjudged insolvent or has been convicted for an offense which in the opinion of the authority involves moral turpitude. Now, what is the procedure provided under the Legal Service Authorities Act for removal of the members or the chairman of the permanent Lok Adalat? The law says that first reason or ground for removal would be a person adjudged insolvent or has been convicted of any criminal offense, and which, in addition to that, it's not just adjudged insolvent or convicted of criminal offense, but also in the opinion of the authority involves that the offense should be of such nature which, according to the authority under the Act, involves any moral misconduct. Or the other ground provided for the removal of the members of the permanent Lok Adalat under the Act is when the member, which includes both the chairman and the other two members, have become physically or mentally incapable of acting such chairman or other person, or has acquired as acting as a chairman or the other two member, or has acquired financial or other interest as is likely to affect detrimental to his function as a chairperson or as other person, or has abused his position to render his continuance in office against the public interest. Now, this point, the other ground as stated under the law says that a person can also be removed from the position of chairperson or member of permanent Lok Adalat when the person has been declared or is or has become mentally incapable of acting as the chairperson or discharging his function as the member of the permanent Lok Adalat. And the other reason would be, as I just mentioned a few minutes back, that the law says that you cannot simultaneously continue to have interest in any company or organization or institution which has been subject to the proceedings of the Legal Service Authorities Act. So this in itself can also become a ground of removal of the member. So when you either have some financial interest and or you start gaining some financial interest in any company, organization, or any institution which is also subject to the proceeding of the permanent lok adalat, or has been brought within the jurisdiction of the permanent lok adalat, and therefore impact their decision or their discharge of official duty as a member or a chairman, then the member or the chairman can be removed from that position, or has abused his position as to render his continuance in office against the public interest. So the act also defines what constitute public interest, and if any member or the chairman continues to abuse his position as against the and uses his powers against the public interest, then he or she may be removed from the position of the chairman or the member of permanent lok adalat. uh, Removal of members, the central authority, or as the case may be. Now, what is the procedure for removal? The central authority, or as the case may be, the state authority shall deliver or cause to be delivered to the chairperson or other person a copy of allegation and list of document and witnesses, and shall require him to submit within such time as may be allowed a written reply or statement of his defense. So, the moment any allegation has been brought against either the chairperson or the members of the permanent lok adalat, in that case, the concerned authority, as the case may be, the central authority or the state authority, may either put it in writing the allegation which has been brought against the member or the chairperson, and shall submit it within such time which will provide the the accused member to write or present a defense for himself. So where the charges has been denied by the chairperson or other person, the central authority, or as the case may be, the state authority, may appoint an officer to inquire into the truth of the allegation, as it may also appoint a presenting officer to present the case on behalf of the central authority, or as the case may be, the state authority, before the inquiry officer. So now what happens that allegation has been brought against, say, the chairperson of the permanent lok adalat, and the central authority or the state authority puts the allegation into writing, and along with the all evidence or required documents sends the allegation to the chairperson. Then in that case, and if the chairperson, after reading those allegations against him or her, believes that those allegations are false, then the chairperson or the other member, whoever the person concerned is, may appoint an officer on his behalf to inquire into the truth of the allegation, may actually send a request to the central authority to appoint an inquiry officer, and the inquiry officer shall, on the behalf of the accused member of the permanent lok adalat, conduct an inquiry and submit its report accordingly to the central authority or the state authority. After the evidence is closed by the presenting officer, the chairman or the other person, as the case may be, shall be given an opportunity to present his defense in respect of allegation, which within such time as may be allowed by the inquiry officer. So then there would be a hearing, and the accused officer would be given an opportunity to defend his case. The inquiry officer shall have power to call witness and record their statement and receive evidence on affidavits. The inquiry officer shall submit his report within a period of 6 months or within such time as by extended by the Central Authority Act and the state authority. Now, the law also provides time within which the proceeding of allegation against the member of the permanent lok adalat has to be completed. And as provided by the law, it is only within 6 months that the inquiry officer shall conduct his inquiry and submit his report to the central authority or the state authority. If the central authority, or as the case may be, the state authority, is satisfied that the charges are provided on the basis of report submitted by inquiry officer, it shall remove the delinquent chairman or other person as the case may be. Place of sitting and working hours. The permanent Lok Adalat may sit at a place specified by the central authority or the state authority as the case may be. So there is no fixed place from where the permanent Lok Adalat should function. It may be any place which as has been notified by the central authority or the state authority. The working days and office hours of the permanent Lok Adalat shall be the same as that of the central government or the state government as the case may be. So, which are the days? So, the holiday or the working day for the permanent Lok Adalat is same and is decided according to the government gazette. So, the same number of days for the central government and state government of same number of working days for the central government and the state government applies to the permanent Lok Adalat also. The sitting of the permanent Lok Adalat as and when necessary shall be convened by the chairperson. So the chairman of the permanent Lok Adalat decides which day, the number of days of sitting and hearing for the permanent Lok Adalat. The central government or the state government, as the case may be, shall provide such staff as may be necessary to assist the permanent Lok Adalat in its day-to-day work. So, when in its day-to-day functioning, when the assistance to be provided is decided and the number of staff that may be required by the permanent Lok Adalat for its discharge of duty is decided and appointed by both the state government or the central government as the case may be. Jurisdiction. Any party to dispute, before the dispute is brought before any court, make an application to the permanent Lok Adalat for settlement of dispute. It is important to understand over here that permanent Lok Adalat discharges function which is an alternative, falls within the alternative dispute resolution system. So, and who are the ones who can bring their matter before the permanent Lok Adalat? Any person who has a dispute and before that dispute is brought to the court of law may decide, instead of taking it to the court of law, can by an application submit the dispute to the permanent Lok Adalat for the settlement. Now, permanent Lok Adalat shall not have jurisdiction in respect of any matter relating to the offence not compoundable under any law. It is important to understand that what is the nature of dispute that can be brought before the permanent Lok Adalat. Permanent Lok Adalat cannot resolve or cannot accept application for resolution of those dispute which are compoundable are not compoundable under the law. So any offense which is criminal and non-compoundable as provided by the Indian Penal Code cannot be decided or brought to the permanent Lok Adalat. The permanent Lok Adalat shall not have jurisdiction in matter where the value of the property in dispute exceeds 10 lakh rupees. Where the matter or the dispute is of civil in nature, it cannot, permanent Lok Adalat cannot decide those cases where the property, suit property or the property in dispute exceeds rupees 10 lakh in value. The central government may by notification increase the limit of 10 lakh rupees specified in the second proviso in consultation with the central authority. However, the provision for exceeding whether the jurisdiction of the permanent Lok Adalat can be exceeded or not. In criminal cases, clearly the jurisdiction of the permanent Lok Adalat cannot be exceeded. It is only those cases which are compoundable in nature and can be settled amicably through compensation or otherwise can be brought to the permanent Lok Adalat. But when it comes to civil matters, although the law provides an upper limit of 10 lakh rupees when it comes to the value of the suit property, but yet the central government may by notification and after consulting the central authority under the act may increase the value of the value of the suit property, and may extend the jurisdiction of permanent lok adalat in such cases to any dispute of civil nature which exceeds rupees 10 lakh. After an application is made, now what is the procedure for filing a case or filing a dispute before the permanent lok adalat? After an application is made to the permanent lok adalat, no party to that application shall invoke jurisdiction in any court of over the same dispute. This is where so this particular provision shows that how permanent lok adalat actually performs judicial functions, because the permanent any matter which has already been submitted to the permanent lok adalat, the same dispute cannot be taken to any other court of law once accepted by the permanent lok adalat. Where an application is made to a permanent lok adalat, it shall direct each party to the application to file before it a written statement stating therein the fact and the nature of the dispute in application. So once an application has been submitted to the permanent lok adalat, then the same procedure of as in any other civil court applies, would also be applicable to permanent lok adalat, where the party is required to file a written statement stating the fact and the nature of dispute which has been brought before the permanent lok adalat. And when the additional statement and reply, if any, have been filed to the satisfaction of the permanent lok adalat, it shall conduct conciliation proceeding between the parties and application in such manner as it thinks appropriate, taking into account the circumstances of the dispute. So once the parties have submitted their written statement and the permanent lok adalat members have looked into the matter, and it is to their satisfaction that yes, the matter can be solved through conciliation, that is without through can be settled amicably, then the lok adalat accepts the matter, the dispute, and shall conduct conciliation between the parties to the dispute in such manner as it may think appropriate, taking into account the circumstances of the dispute. Proceedings. The permanent lok adalat shall, during the conciliation proceeding, assess the party in their attempt to reach amicable settlement of dispute in an independent and impartial manner. So, the law says that there should be fair play between the parties and the members of the permanent lok adalat, and it is very important that the dispute settlement should be amicable in nature. That is, it should be done peacefully and without any adversary arguments. So the both party should reach to a consensus before a matter is finally decided, before a award or a decree is made by the permanent lok adalat. It shall be the duty of every party to application to cooperate in good faith with the permanent lok adalat in conciliation of the dispute relating to the application, and comply with the direction of the permanent lok adalat to produce evidence and other related documents before it. So the law also makes it binding upon the parties to the dispute that once they have made an application for the matter to be resolved amicably by the permanent lok adalat, they should cooperate in good faith as far as possible in terms of both providing documents and reaching a conciliation with respect to the dispute. When a permanent lok adalat is of opinion that there exist elements of settlement in such proceeding which may be acceptable to the party, it may formulate the terms of a possible settlement of dispute. And only when the permanent lok adalat is of opinion and is satisfied that there exist elements of settlement in such proceedings which may be applicable to the parties, it will formulate the terms under which the settlement should be arrived. Where the parties fail to reach the agreement, the permanent lok adalat, if the dispute does not relate to any offence, can decide the dispute. It is further provided that the permanent lok adalat shall, while conducting the conciliation proceeding or deciding a dispute on merit under this act, be guided by the principles of justice, objectivity, fair play, equity, and other principle of justice, and shall not be bound by the Code of Civil Procedure and the Indian Evidence Act. So the procedure as provided under both the civil law and the criminal law is not applicable when a matter or a dispute is submitted to the permanent lok adalat. In such cases, the matter is to be settled purely on the basis of justice, equity, good conscience, and fair play. Award: how the decree or the award is passed by the permanent lok adalat and what is the nature of this award. Every award of the permanent lok adalat under this act, made either on merit or in terms of settlement agreement, shall be final and binding on all the parties thereto and persons claiming them under them. So the award is made binding under the law. Any award passed by the permanent lok adalat would have same status as any award passed by the court of law and is binding, and shall be deemed to be the law also provides that the award made by the permanent lok adalat with respect to any dispute shall be deemed, that means it shall be at par and shall be treated as the decree of the civil court. Every award made by the permanent lok adalat under this act shall be final and not called in question in any original suit, application, or execution proceeding. It can go to court only as a matter of an appeal, but not in cannot originally be again filed in any court of law. And the permanent lok adalat may transmit any award by it to the civil court having jurisdiction, and such civil court shall execute the order. So once an award has been passed by the permanent lok adalat, the for a binding decree, the matter can again be submitted. The decision or the award made by the permanent lok adalat can be filed to the civil court for an execution decree. Due to high pendency of cases across the court in India, that has made it extremely difficult for the litigants to get effective justice within a reasonable period of time. The law has provided with an alternative dispute resolution system, and permanent lok adalat is one of those measures for an alternative dispute. In order to address this never-ending problem, the lok adalat mechanism can prove very effective, and further, it is necessary. Why lok adalat is important? Because it is necessary to spend economic and human resources in settlement of dispute and bring back the prestige to the judiciary. Thank you.